All right. Well, thank you for being with us in the second keynote address of the day with a Professor Stephen Freeland, who is actually in Paris right now at the conference going on there at the same time. Professor Freeland is an emeritus professor at Western Sydney University. He has ample background and experience on international law, and he will be talking today about regulating space resource activities on the moon, which should be very interesting considering that the main theme of our conference this year is precisely going back to the moon. So I will now give the floor to Professor Freeland.
Thank you so much, Daniel. Yes, I'm in Paris. It's a pleasure to be here. At least it's better that I'm in Paris rather than my home Sydney, because if I was in Sydney, it would be some late time of day. But it's a pleasure to be here. I hope that everybody has enjoyed the conference. I've had a look at the program, and it looks spectacular, and I'm sure there's a lot of interesting discussion. As Norm mentioned, I'm currently here in Paris. The International Astronautical Congress has just completed yesterday. They had, I believe, about 8,000 delegates, and it just demonstrative of the fact that space is of great interest to so many people in so many ways. So Daniel has very kindly invited me to speak about the regulatory, governance, diplomacy, geopolitical aspects of proposed called space resource activities on the moon and celestial bodies, other celestial bodies, asteroids, meteors, perhaps Mars at some stage. And I'm very happy to do that. I, amongst other things, am an international lawyer. I'm part of the Australian official delegation to the United Nations Committee on the Peaceful Uses of Outer Space, which discusses a whole range of legal aspects of space. I'm a principal in a law firm called Azimuth Advisory, which is a specialist space law firm. We have clients from around the world, governmental, intergovernmental, and of course industry. And perhaps of even greater relevance to the theme of this conference, I've been appointed by the United Nations Committee on the Peaceful Uses of Outer Space, which is about 110 countries, including virtually every country that's involved in space. I've been honored by being appointed by that UN body to co-chair all of the discussions about space resource activities, with a view, depending on the views of the 110 countries, to come up with principles and perhaps eventually the legal international governance frameworks for undertaking such activities. And I'll talk about that briefly. I'm going to talk for about 30 minutes or so. If you do have questions, I'd be delighted. If we don't have enough time to answer your questions, on the final slide, I'll have my email, and feel free at any time to contact me and just mention that you've heard this address, or perhaps you can go through Daniel and the organizers. No doubt you're fully aware of this, and no doubt this wonderful conference has made it clear. But as you know, I'm going to be talking about legal, governance, geopolitical aspects of space. But space is so many things to so many people. Besides those, it's clearly also about military and national security interests. I've seen you've had some very interesting discussions on that. Clearly, it's a huge and growing commercial area. It's about science and exploration and culture and religion and heritage and so many aspects of civil society. Space, as you know, literally touches every person on the planet. Space is so integrally involved with the future of humanity. Space is so involved with our human rights. And so the important thing about developing not only frameworks for activities, but governance and regulatory frameworks, is to ensure as much as possible, and I'll come back to this, that all of those perspectives are taken into account. This is not going to be a legal lecture, but some of you may be interested to know that, well, we're talking about space, and I'm not sure whether anyone has covered this in a previous talk, but by and large, we do not know, from a legal perspective, where space begins in terms of any particular altitude above the Earth. Why is that important? You'll all know that the airspace, for example, the airspace above the United States, is subject to American law, US law. I cannot fly and enter US airspace without permission of the authorities, and I have various duties if I do that. Outer space is a different legal type of area. Outer space is an area that we call beyond national jurisdiction. So whilst US law applies to the airspace above the US law does not, although there are some wrinkles on that, but by and large, US law does not apply to the outer space above the United States. It applies to US satellites and various constellations, but not to the area itself. So there are two diametrically different legal perspectives: airspace, outer space. And you would have thought, therefore, that the obvious question, particularly lawyers, but the question to anyone is, well, where does one stop and where does the other begin? Because if you have that boundary, in a sense, you're determining the upper limit of the sovereignty of a country. And the answer is, we have not agreed. We do not know where that boundary is. Of course, there are many theories, there have been many discussions about it. It's not really a legal question anymore, it's a political question. And by and large, and I generalize here a bit, the larger spacefaring countries, including the United States, have always argued that we don't need to know where that boundary is. Nothing turns on it, space works very well, it's not necessary. And by and large, and again I generalize, the less developed spacefaring nations and those that don't have space capability want to have that boundary. And the question there and the difference in approach really is about sovereignty. Because of course, if you're capable of doing lots and lots of things above where I'm sitting, you don't want to have that hard boundary. Because once you've got a hard boundary, if you go below it, you are clearly violating the sovereignty of the other country. If we don't know where that boundary is, if there's a wiggle room on it, then that doesn't constrain you above as much to do things above my territory. So it really is a political issue. So even though we have two different frameworks, we don't exactly know where airspace ends and outer space begins. Outer space is also, as I mentioned, now a really burgeoning commercial area. So originally it was about countries only, and it was originally about a small number of countries. But if you fast forward to where we are now, of course, it's about countries. There are now approximately 80 spacefaring countries. By that, I mean 80 countries that have sovereign capability to do certain space activities, although amongst them, of course, there's a wide variety of capability. That, of course, means there's still 120 countries approximately in the world who don't have that sovereign capability. So that's also an issue because every country is dependent on space for its critical infrastructure functioning. Literally, if we had a day without space, and there have been, particularly by the military, war games, other things, postulating a day without space, literally, our lives would go back into the dark ages. Our financial system would collapse. Our transport system would collapse. Our sewage system would collapse. Our infrastructure would collapse. All of these things would collapse. Clearly, it would have implications for national security. Clearly, it would have implications for agriculture. It would have implications for so many things. So space is incredibly important. and every country is dependent on it. But not only are states now involved, there is this rapidly expanding commercial framework for space. Clearly, in the United States, you're aware of well-known companies, SpaceX and Blue Origin, and OneWeb and Virgin, but there are literally hundreds of commercial companies now engaged in space globally. The global space economy was measured at approximately 380, 400 billion US dollars in 2021. But here's an interesting fact. During the darkest times of COVID pandemic, there were only 3 economies that grew in the world. One of them was the pharmaceutical industry, for obvious reasons. The second one was the digital, I don't know how to describe it, but Netflix, that industry, for obvious reasons. And the only other industry that grew in the world, as the world economy was retracting, was the space industry. And so it has been growing at 6 to 7% year on year over the past 2 decades. And in my former life, I was an investment banker. So you take what investment bankers perhaps say with a grain of salt, but depending on which investment bank you believe, this industry will be a $1 trillion industry in the not too distant future. So space resources, what's at stake? You're aware of this, no doubt you've had discussions already, and you'll have more in this conference about what may be available. So let's talk about the moon and focus on the moon, given the theme of this conference. So the initial ideas about, if you like, extracting resources from the moon was this. There are, for example, rare isotopes of helium, one called helium-3, no doubt you've heard about it. And we're told by the scientists that helium-3, if it could be utilized in fusion technology, if we could develop fusion technology, helium-3 could, through that process, could create incredible amounts of energy and power, which would, of course, solve the world's problems. So wouldn't it be great if we could go to the moon and there are significant deposits of helium-3, bring that back to Earth? That would be great. Another reason why people postulated that we should be, if you like, mining the moon was that, hey, to the extent we do it on the moon, then we're not doing it on Earth. And therefore we are, if you like, polluting less on the Earth than we would otherwise. So wouldn't that be great for humanity? So the original ideas about extracting resources from the moon was go up there, extract whatever you want, bring it back to the great benefit of humanity. And here's where the investment bankers come in again, because by and large, that's great in theory, but there is no economic business case that supports that, let alone all of the incredible technical encompassed. So now the thinking is different. And now concentration, at least in the shorter term, it's about water now. On the clearly is important. Clearly, water is important for the sustaining of life. But the thinking is that water could be extracted on the moon, processed relatively easily, create fuel that could be then used as the moon to be, if you like, a launch pad further on. So now the thinking is we leave Earth, we go to the moon, we extract, we process, and we deal with it there, i.e. we don't bring it back. And so that's a totally different argument. And, you know, it raises issues about benefits, because now the thinking is to, and NASA is very much involved in this, is the thinking is to create what we call a cis-lunar economy, an economy off Earth. My thinking about this is as follows. There will only be a relatively small number of countries and, of course, private sectors within their jurisdiction, because the private sector will drive a lot of the technology. that will be capable of going up there, extracting, processing, and selling. Likewise, there will be only a relatively limited number of companies, and again, they're private sector participants within their jurisdiction, who will be able to go to the moon and be the buyers. And so you're creating this cislunar economy, but the market is, in terms of at least numbers of actors, a lot smaller. And so you have to recalibrate the notion that we're doing this for the benefit of the global humanity. Now, I'm not expressing a view one way or the other, but you can see the argument has changed dramatically. And there are those that say this is a great thing to do, we must do it. And indeed, you'll know that by and large, humanity has made a decision now that we will do it, albeit, there are many, many challenges until it gets to that point of commercial exploitation. But there will be always those that question either the ethical, the legal, or the moral stance on this as to whether we should. But that's an argument that could go on for a long time. We have laws in space. I know that Daniel told me you had someone yesterday talk about law. We have a set of United Nations treaties which set fundamental principles. I'll talk about them briefly in a moment, that are relevant for these sort of activities, but not specific necessarily. And we have other instruments that acronym UNCOPOS is the UN body that I talked about, United Nations Committee on the Peaceful Uses of Outer Space. It's 110 countries, but as I said, it's every country that really engages in space, including all of the major ones. So it has, as well as these treaties, it's developed other non-binding but equally important guidelines. And then we have other areas that are beyond national jurisdiction, like outer space, that we have developed governance structures for in terms of using the resources. The International Telecommunication Union, ITU, regulates a particular orbit. Well, it regulates radio frequency spectra, which is really important, a really important resource. And it also regulates a particular orbit known as the geostationary orbit. No doubt you've heard about that in this conference, which has incredible value because of its characteristics. And so that's a natural resource in space that we now govern at this intergovernmental level. I've also got there the International Seabed Authority. So the deep seabed, which is the seafloor under the high seas, that's also an area beyond national jurisdiction. So US law does not apply to the high seas. It applies to US vessels on the high seas, but not the area itself. So similar to space. And there's an authority this time based in Jamaica that regulates applications to mine the deep seabed. So we've got some ideas about, governing areas beyond national jurisdiction in terms of the extraction of resources. So perhaps we've got lessons to learn there. I won't go through the laws in detail, but I'll raise the questions that the existing legal framework pose and how they might be relevant to space resource activities. So the Outer Space Treaty, which was the first of these treaties, which really sets out those fundamental principles. Some call it the Magna Carta of space. I'm not sure whether that's accurate, but it certainly sends out the principles that every activity has to adhere to, and all of the major spacefaring nations are party to that treaty and bound by it. The United States has constantly reiterated that we must subscribe and adhere to it. So it designates that space is free to use, but there's also a freedom of access for everybody. So in a sense, I can go anywhere in space and you can't impede me. So obvious questions will arise when we're having resources. Space is an area that is not subject to appropriation. So no country, and by extension, no private company within their jurisdiction, can claim ownership of particular areas or space as a whole. So how does that work with the idea of extracting resources? Space is important for peaceful purposes. That is the mantra of space. Even though, of course, as I mentioned it right at the beginning, space is important for military uses on Earth, terrestrial uses. Clearly, we can't deny that, how important it is. But space itself is an area that is designated for peace. So in the extraction of resources, if you look at the history of warfare on Earth, the idea of extracting resources has always been a bit of a catalyst to drive wars and conflicts. So we have to be careful there. There are notions of responsibility. Countries are responsible for what goes on in space, even if it's undertaken by those within their jurisdiction, by private companies. So the United States is responsible for the activities of, let's say, SpaceX in space, given that SpaceX is a US corporate within the jurisdiction of the United States. You know, my country, Australia, is responsible for any Australian corporates that go to space. And so the country has to ensure that the private entity does the right thing. There's a liability regime if things go wrong, collisions in space, debris falling down, and we need to also work out what liability might be when things happen on the moon. There are notions of not interfering with each other and of consulting, of paying what we call due regard. So if I want to do something in space, I should, before I actually undertake it, I should pay what's called due regard to what you're doing in space. Again, that raises a whole range of issues if you've got an area of interest to many corporates or countries about resource extraction. How do we deal with that? And space is about compliance and cooperation and sharing information. Well, of course, that's great, but countries and corporates where there's commercial in confidence information sometimes are not great at doing that. We also have another treaty in 1979, the Moon Agreement, which deals specifically with the idea of extracting resources. It only has, and I say only in inverted commas, 18 countries that have ratified it. By comparison, the Outer Space Treaty that I just talked about has, I think it's now 112 countries. The United States is not a party to the Moon Agreement. The United States is a party to every other space agreement. But this has notions of what do we do when we get to the point of being able to commercially exploit resources in space. My country, Australia, is a part of that. We also, as I said, have other documents and instruments about creation of debris and trying to limit that, about the sustainability of activities in space. And then there are other questions that arise about heritage. You know, what do we do with existing things on the moon? You know, we have to protect the footprint, which is always the famous example. How do we protect operations? How do we monitor that people are doing the right things? So, what are we doing about it from a governance framework? Well, there are many layers of what I call conversations going on. Various countries, really starting with the United States in 2015, under the Obama administration, a number of countries have passed national law that promote the idea of extracting resources. So the US law, for example, says that any US national that, let's say, goes to the moon, extracts resources, will have ownership rights, property rights, will be able to commercially exploit them, sell them, etc., under US law. But that US law also says subject to United States international obligations. And so even though the law promotes the notion of space resources, it still feeds back to the international framework. And it's the international framework that really drives the legality of all of this. Other countries have done the same. We have at the bilateral, or what I call mini-lateral level, you might have heard of the Artemis Accords. I presume they've come up in your discussions already, which are political agreements. And I'll talk about that briefly. Other countries have ambitions as well, China and Russia, for example. And then civil society has got a lot to say about it. I mentioned the Artemis Accords. You're aware that the United States, well, in fact, NASA has bilateral agreements, that is one-on-one agreements with the space agencies of now, I think it's 20 other countries. And these accords, they're not binding. They're expressed to be political agreements. They're expressed to say, we are entering this political arrangement, but the centrality of all of the law is the Outer Space Treaty. And here are the various headings. The ones in bold are not covered by the Outer Space Treaty. So they extend, if you like. And the Artemis countries, particularly NASA in the United States, tend to want to say this is an operationalization of the Outer Space Treaty. Okay, this is a political discussion. There's a lot of support for it. There are a lot of good ideas, but it's only a relatively small number of countries. So I mentioned the United Nations. So there are all of those conversations going on that I mentioned, and essentially they are all now inputs to a UN process. There's lots of words on this screen, but let me just say that COPOS it has a legal subcommittee, but it's 110 countries. And those countries decide what they want to talk about. What are the major pressing legal issues? Space resources is one of them. And when they want to move from a discussion item to an action item, they establish what's called a working group, but a working group is still 110 countries. It's not a group of 3 or 4 people. They established a working group on space resource activities. As I said, I have the honor of chairing that together with a wonderful lawyer from Poland. We've reached consensus because decision-making at COPOS is based on consensus. So every country has the power of veto. We've reached consensus on how we're going to move forward for 5 years. And those documents are all public. And if anyone, I've got the references there, but if you want, I can point you in the right direction if you want to see them. And we have achieved consensus on really sophisticated documents moving forward, even in this very, very challenging geopolitical world. And, you know, whilst people criticize the UN and the space community sometimes says that the UN is too slow and, you know, industry wants decisions tomorrow, I challenge you on this. You know, where else in the world are you going to get consensus on anything? You get it here, even including countries like Russia and China and Iran and the United States and Canada and India. And all of those countries have agreed, because each one of them and all the other 110 countries have a power of veto because it's a consensus basis, agreed on the way forward. Why? Not because I've done a great job as a chair, but because it's in their, they see it's in their interest to do so. So we're now seeking initial feedback from these countries. We've asked them a series of questions. Of course, it's up to them how they respond, but here are the sorts of ideas that we're seeking input. We're going to tabulate that, assess that, summarize it, and then we will start the discussion leading to one of our outcomes, which is a set of principles on this activity. So I've almost finished. I've got 2 more slides to really, if you like, encapsulate. What are the risks? What's the future now from governance and regulatory? And this is, of course, about geopolitics as well. Will, notwithstanding, you know, we've now set up the working group, we're going to move forward, but every word, every concept will be debated. We'll have all these inputs coming in. Will this working group be able, because in the end, I'm a facilitator, the decisions are made by the 110 countries. Will this working group, will these 110 countries agree a framework? And what would that look like? We don't know the answers to that. We're really still asking the questions rather than coming up with any answers. What happens? What are the risks if we don't reach a multilateral agreement? That countries continue on their bilateral, minilateral, or national paths. The danger then being, even though, you know, some of the rules that they put forward are interesting and no doubt very helpful, but the danger being that you'll have different groups of countries operating in close geographic proximity in a hazardous environment, but applying and working to different standards and different rules. And that really challenges the notion of trying to ensure that we minimize the risk of conflict and that countries don't become, if you like, nationalistic and claim areas of exclusion. And that would, of course, defeat fundamental principles of law. So the last slide is this, and I'm a bit of an optimist, otherwise I wouldn't do what I do. But it's going to be tough, right? But clearly the world has changed. So that first treaty in 1979, the Moon Agreement, which talked about this issue, but only has a relatively small number of countries that decided to be bound by it. Things have changed dramatically since 1979. This issue of how we govern our utilization of space resources is, I always call it one of the big issues in space. There are a number of them. You've talked about debris, you've talked about space traffic management, you've talked about managing large constellations of small satellites. Resource exploitation is another of the big issues in space. Indeed, it goes to the heart of our relationship with space. What is space to us? Is it simply, and clearly I disagree with this proposition, is it simply something that we can exploit? And what are the dangers of that and ignoring the fragility of space, etc.? For me, amongst a whole lot of issues that arise with this notion of exploiting the resources of space resource activities, etc., and there are so many issues involved, but for me, the apex fundamental issue is avoiding conflict, avoiding that. And in my opinion, at least, the only way to best minimize the risk of conflict and maximize the benefits of any activities is through a multilateral process. What we need to do, and this is what we're striving to do at the UN, is to give every voice, let every voice be heard. Obviously, there will be disagreement. Obviously, there'll be tough negotiation. Obviously, there will need to compromise as we move forward. But you need to have a process, in my opinion at least, where every stakeholder, and in this case, it'll be the 110 countries, representing a whole range of interests within their own country. Every stakeholder has the opportunity to express views, has a buy-in on the process. It's an inclusive process. Just know from your own life experiences, if you are involved in a process, have an opportunity to contribute and buy in, even though it doesn't necessarily in the end reflect exactly what you want, you are more likely to adhere to it rather than me imposing on you a set of norms and principles that you had no input. And at the geopolitical level, countries don't accept that. They won't accept rules being imposed on them if they've had no opportunity to at least contribute to the process. So the multilateral process that we're engaged in is, in my opinion, the best way forward. But we need to hear all of those voices that I mentioned at the beginning. And so the establishment of this working group, I think, is a really important geopolitical decision. Obviously, we need to, in my opinion, have commonly understood and agreed rules of the road in whatever format. Doesn't necessarily mean that all of the stakeholders will be cooperating and working together, and indeed they probably won't. But at least they'll be operating, in my opinion, under the same sets of rules of the road, and that therefore, in my opinion at least, will minimize the risk of conflict. Nothing will be perfect. There are always risks, but we've got to do whatever we can, given that humanity has decided this is an activity we want to do. We've got to do whatever we can to find a way forward to reach a path that minimizes the risk of conflict. So I'll leave it at that. As I said, here are, if you want to take a screenshot, I've got 3 email addresses, I apologize. Feel free to contact me on any of those. Probably the middle one is the one I use the most. With that, I'll stop sharing and I'll pass the screen back to Daniel.
Thank you, Professor Freeland, for such a great summary of the international and legal landscape in regards to regulation of space activities. We have 2-3 minutes for questions. Here's a question from Charles Peters. Should airspace be dictated by that nation's capability to operate at certain altitudes?
You said airspace, but did you mean outer space? Or
Yes.
should outer space be governed by a particular country's capabilities? That would, in my opinion, at least, defeat the whole notion of space being an area where we all have a stake in it. And the rules, clearly the rules will be agreed by negotiation. Some countries will have greater negotiating power than others, but it can't be and must not be dictated by one or two or three. Obviously, they've got the most to say about a lot of these issues, and they will be vehement in their opinions. But if we have dictation based on capability, that I think forces the situation where there will be those that don't want to adhere and won't agree. So that's my view. Thank you.
Thank you. Another question from Linda Sapp. Does a common platform exist for countries to share due regard?
That's a really excellent question. Thank you. So I mentioned we have this notion of due regard as an obligation. The obligation is on me if I want to engage in space activities to take account of what you're doing. But of course, one, I may not know what you're doing or what you're planning to do. And two, taking due regard doesn't mean I stop just because you're doing something. But we do have common platforms, and the UN COPOS is an excellent common platform because it is a talking shop. I mean, the UN often is called a talking shop where countries can express what they're doing, what their plans are, and of course, all of the work is done over cups of coffee on the sideline. But there is also a notification process through the Secretariat of the COPOS. So yes, there are platforms. That said, countries sometimes are not very good at communicating with what they're planning to do, and we must change that way of thinking as we move forward.
Thank you. I'm afraid we don't have time for more questions, but if you would like to email Professor Freeland, if you didn't have time to copy his email address, you can send a note to the organizers of the event and we'll facilitate that information. And we invite you to attend our next set of panels in about 10 minutes. So thank you very much, Professor Freeland, for being with us today from Paris.
You're more than welcome, and I hope the rest of your conference is as interesting as no doubt it already has been. I wish I could attend more, but I'm very happy to continue a dialogue with those who are interested. And Daniel, thank you again to you and your organization for allowing me to speak. I really appreciate it. So all the best from
Thank you so much. Have a good night.
Good night. Bye-bye.